Emery. I think she might be the committee. Like she.
Okay. What's that? I was just curious.
Oh, okay.
So just wait for the announcement. Hold on. Don't have it until I know we're actually doing today. I'm gonna wait to fill out a witness form until I know we're
Oh yeah. Unless it's going to fiscal. Yeah, I mentioned
to get a specific.
Oh yeah.
It's not like I didn't say.
Oh yeah.
What's going on?
Yeah, that's it.
Sending all the branches.
Here we go.
Public service deal. They have bats. So that leaves
Okay, now there are three cars.
I learned that from Florida.
I guess I should get mine just in case.
Our science teacher. I'll give you $1,000.
You know, it's nice. Somebody either someone
I ended up having to do all.
Yeah, I don't think it sounds
The whole thing. I was like to do that. And then I think I realized the
I was going to say, did you even bother to leave? We're going to open the Government Reform Committee as a subcommittee this morning. We'll probably pause at some point when we have a quorum and take rolls. But I'd like to go ahead and get started since we're shorter on time than usual this morning. So first of all, we're going to take House Bill 153. Representative Corlew, would you like to begin?
Thank you, Mr. Chair, members of the committee. Kevin Corlew, State Representative, District 14, Kansas City. I'd like to be here and present this bill. This legislation is about increasing the reliability of expert evidence that is presented to Missouri juries. And to that end, better serving the truth-seeking function of our courts. This bill is similar to legislation that this General Assembly passed last year with some couple amendments or an amendment that we can address, but it's similar to the bill that was passed out, SB 591 last year, that was subsequently vetoed by the governor. Missouri's lack of reliable expert witness standards has landed the state on the American Tort Reform Association's list of judicial hellholes for this 6th year in a row. In fact, in the most recent ranking, St. Louis courts were named as the worst in America because of the unreliable expert witness standard and because of recent interpretations of our venue statute. This bill just deals with one of those aspects, and that is the expert witness standard. The lack of a reliable expert witness standard is a sufficient source of risk for businesses looking to locate or expand in Missouri. This is evident from the U.S. Chamber of Commerce's ongoing report that they put out, where they rank the states with respect to how businesses perceive how fair and reasonable the state's tort system is. Participants in the survey were comprised of a national sample of more than 1,200 in-house general counsel, senior litigators or attorneys, and other senior executives who indicated that they're knowledgeable about the litigation matters at their companies, and that they've recently and within the past 4 years had litigation experience in Missouri. Based on those surveys, Missouri's court system ranked number 42 in 2015 as one of the least fair and reasonable environments. HB 153, which is one aspect that seeks to implement a fair and reasonable standard that does not favor one side or the other, whether it be a plaintiff or a defendant or a prosecutor or a defendant in a criminal case. The standard applies to everyone equally, and just sets forth a working standard, an objective standard that an expert is one who can be deemed an expert because of knowledge, skill, education, training, and then subsequently or after that also that the opinions that the expert is going to espouse are based upon reliable science, reliable principles and methods, and sufficient facts and data. This would implement the judge as a gatekeeper, similar to what's known as the Daubert standard that has been in place for about the last 25 years in all federal courts throughout the nation, including the federal courts right here in Missouri, as well as more than 2/3 of the states that have adopted the standard for their states. And what this standard says is, has mentioned that it sets forth who an expert is and what basis they can testify on their opinions. The Supreme Court has admonished that expert witnesses serve an important role. In fact, the Supreme Court, in the case that bears the name of the Daubert, said that expert witnesses have the potential to be both powerful and quite misleading. And so that's why there needs to be sufficient gatekeeping responsibility for the judge to make sure that someone whom the jury has been informed is an expert, to make sure that what that expert is testifying isn't just junk science, but there's some reliable basis. Now, the judge does not make a determination whether he or she likes the expert witness, whether he or she likes the opinion, but rather just is it an opinion that's based on some reliable methods for getting there, and then the jury ultimately decides, judges' credibility and weight, and that they're going to give that expert witness. But the judge's role is just to make sure, first of all, that expert evidence being presented is reliable. A recent case in the Supreme Court kind of magnified how important experts are. As last week, the Supreme Court struck down a case in Texas dealing with in a criminal matter where the expert witness testified basically that on a racial matter that just overgeneralized and said that science proved that people of a certain race may be more prone to the recidivism and violence, and the court said, especially when that comes from an expert, there's a higher level that you've got to look at. Now, that case doesn't necessarily go to the expert standard, but it does highlight that the importance that experts serve in the case. Now, there was a case in Alabama about 2 years ago where the Supreme Court did change a death penalty case because of evidence that had been entered into when Alabama was under the old Fry standard. Subsequently, the Alabama had entered into the newer standard. The court looked at the evidence that said that it was not reliable, that the gentleman was convicted on unreliable evidence. So these are cases that really signify how important expert witnesses are. And it should not be determined on who an expert is or what he can testify to, or she can testify. It should not be determined only on how much someone can pay somebody. That shouldn't get into it. But under a system that we have now, I feel like the deeper pocket always has the advantage, because you can always find someone out there that will testify what you want them to say if it suits your case. But that's not the standard we should expect here in Missouri. That's not a fair standard. That's not a balanced standard, and that's not one that says that justice is blind, as we see the lady justice with the blindfold. It should be determined not who you are, not how much you, not the kind of wealth you have, not whether you're black or white, not whether you're young or old, but whether you're there, do you have a fair opportunity to present your case? And that's what this case goes to. Now, I did want to just touch on it. I want to take questions, and I know we have some witnesses that are here to talk about this as well, but this is just to highlight a couple things. This is a clear and understandable standard. It increases efficiency in the expert qualification process, because all of the parties will know what it takes to be an expert, and whether you practice for an attorney that practices particularly on the either side of the states. You'll have one standard that you know, a uniform standard that you can look to, whether you practice in Kansas, Missouri, Illinois, Missouri, or in the federal courts. So there's going to be an efficiency gain, because you don't have to change your standard. You do a whole bunch of research, and in terms of each time you qualify an expert witness in a different form. It's something that you can rely upon. So there's an efficiency gain in the process there. Litigation costs are at an astronomical high here throughout the nation, and this is one way that we can help make sure our litigation costs are lowered. In addition, the court itself will have a reliable body of evidence to look at, because of what I mentioned, the Daubert standard, which has been adopted throughout the nation. Even our Supreme Court, under the existing standard, has said that to the extent that our existing standard mirrors the federal standard, that they can look to other courts and other cases for guidance upon that. That doesn't mean that a Kansas case becomes the law in Missouri, but what it does mean is that the court has a body of established law that they can look to determine if someone that's being proffered as an expert really is or isn't, and the court will save time in doing so. The other aspect on efficiency that I want to mention is this would enable the parties and the court to be able to determine at the outset who the expert is and whether their testimony will be admissible. This allows for a earlier process before you go through the entire expense of a trial, an earlier process to be able to determine, is it going to be able to go forward with the evidence that they have. This would allow the parties to if there's a determination made one way or the other on an expert, this allows the parties to enter meaningful, informed settlement discussions. This may allow the court to make earlier summary judgment decisions, or certainly at least be able to narrow the scope of the trial or the issues. So there's an efficiency gain in that process. To talk about a couple of things that you might hear, I want to make sure that it's clear that this does not require a separate hearing. In fact, Missouri already has a standard or a procedure by which you can challenge an expert. That won't change in terms of this bill. This just changes the standard by which the judge would determine if that person's testimony should go to the jury. That would not change. A hearing would not be required. That extra step is subject to the court's discretion. In terms of an amendment that we made on the floor, we in the House, we determined that this would apply the standard would apply in only cases in which there is a right to a jury trial. So in cases in proceedings in which there is no right to a jury trial, so an administrative proceeding, for instance, this expert witness standard would not apply. The same standard that is now in place would apply. And it was a reasonable agreement, I think, that we made between different people who had different interests on this bill. That the real target of the bill is to make sure that what's given, the information that's given to juries, is reliable. You also may hear today, I did want to mention one part. I think the Department of Mental Health has asked that they have an amendment that would, there's a section in here that says an opinion is of the bill. An opinion is not objectionable just because it raises an ultimate issue. In a criminal case, an expert witness shall not state an opinion about whether the defendant did or did not have a mental state or condition that constitutes an element of the crime charged or of a defense. Those matters are for the trier of fact alone. That provision in there is the current law now. That comes from U.S. Supreme Court law and also from Missouri court law that says that an expert may not testify that the defendant possessed the state of mind necessary to be guilty of a particular crime. That's because the elements of a crime are for the jury. In a civil case, you can have an expert testify to what's called the ultimate issue. And that distinction was done away with years ago. They used to not let the expert testify to one of the ultimate issues. But in a criminal case, that province, the specific elements of a crime, that is, did they have the mens rea, did they have the intent to commit the crime, that's for the jury and jury alone. However, the Supreme Courts and the courts in general have also said that there is no error in allowing the prosecution to ask a defense witness if the defendant was suffering from a mental disease or defect. So this provision in the bill does not prevent testimony on the underlying person's state of mind and the underlying condition. But what it does say is that an expert can't take that final step and say they did or did not have the intent to make the crime. So therefore, so what the Department of Mental Health has said is that they in certain cases have somebody testify to the person's condition. I will say that's an unnecessary amendment to make to this because that's already provided for in existing law. As I said, this codification does not change existing law as it is and has been for many years throughout the nation. This just sets forth it in codification. So there's no amendment necessary in my mind that you would have to carve out the ability to the Department of Mental Health to be able to issue their report. They have that ability now. They will have it even after this legislation is passed. With that, Mr. Chair, I'm willing to take questions. Thank you for your time.
We're going to pause just a minute and take roll.
Senators Emery,
Here.
Schatz, Eigel,
Here.
Munsinger,
Here.
Rizzo, Rowden, Sifton.
Here. We have a quorum, so we'll now enter into a full hearing process. We have a phrase that is sometimes used over here, Representative, called filibustering your own bill. We'll open it now for questions for the representative. Senator Sifton.
So what is an example of a Missouri case where the admission of junk science testimony that Daubert would have prevented resulted in an unjustifiable outcome?
Senator,
Representative, can I interrupt just one second? If you can remember that question, I meant to make an announcement before we went to questions. If anyone's here for the hearing on Senate Bill 175, due to the shortened time period, we postponed that hearing. I plan to notice that up for next week, and so we will not be hearing Senate Bill 175. I apologize, Senator.
Thank you, Senator. Good question. There's been certain cases, in particular, some of the St. Louis cases that they mentioned where expert evidence has been allowed in those cases, but they have not been allowed in other cases. I know the Johnson Health cases are an example where Missouri courts have let in expert evidence that throughout the country have been excluded under the Daubert standard. There's a case in St. Joseph with regard to the tannery there, where case was where experts were allowed in that would not have been allowed in under the Daubert standard. There are criminal cases that that where DUI evidence has been let in, it would not have been allowed in there.
Well, you'd agree with me that we have separate legislation pending in this bill to try to address that matter. It's somewhere on the Senate.
No, that's a different issue. That was,
DUI?
yes, yeah, as far as DUI experts, there have been cases where a dentist has been allowed to testify on the DUI standard in Missouri courts.
Thank you.
Other questions for the representative? And you probably are going to have witnesses that answer this, but can you point out the differences between your bill and Senate Bill 200? Have you reviewed Senate Bill 200? Senate
Yes.
Bill Library's bill?
Yes, I have.
So what are the differences between those two?
The only differences that I'm aware of, and unless something has changed in the last couple of weeks, but are the changes that we made on the floor, and that is to narrow the scope of this bill so that it applies only in those cases in which you have a right to a jury. So there's some aspect of the case. There's some claim that calls for a jury trial, and at least the right to a jury trial. Now, parties can always decide that they want to waive that right, but if there's a claim in the case that has a right to a jury trial, then this standard applies. That's the only aspect that I know of, Senator.
And you said that there was an amendment added on the floor of the House that you think is unnecessary? Did I understand?
No,
right?
no, Mr. Chair. There's the Department of Mental Health has come forward that's seeking an amendment to the bill, and I think they'll testify on that and just want an opportunity to speak to that. I don't think it's necessary. I don't think that I don't think it's harmful. Don't get me wrong. I don't think what they're saying is, but I just think under existing law, it's very clear and has long been held that way, that they would still have the ability to enter a mental health report.
Thank you. Any other questions, Senator Sid?
If I may, with respect to the House amendment that was added regarding bench tried cases, and I see the verbiage is cases in which there is no right to a jury trial. I suppose there are cases where there is a right to a jury trial, but the parties agree to waive. Why not simply say in bench tried cases, we don't need to worry about this?
That's a good question, Senator. And here's the reason why we wouldn't just blanketly say that. Because, you know, the parties can waive their right to a jury trial at different periods throughout the litigation. So in other words, if you set up a system where it only applied in a jury trial, you could have the parties working on an understanding that the Daubert standard applies, doing all their discovery, depositions, reports, motions, all of that under the Daubert standard, and then one of the parties waives it before trial. So then you all of a sudden have a different standard and would require a whole new set of discovery. The parties in the court need to know from the outset what the standard will apply to guide the discovery process and litigation.
I hear what you're saying on that, and I get that jury trials can transmogrify into bench trials late, and also, unfortunately, bench trials can suddenly become jury trials late.
Right.
State Ex Rel. Lee and Hardy v. Sherry being the most painful example that I've seen of that. When I had a bench trial set 6 weeks out from that particular decision, that suddenly became not a bench trial. But it just seems to me that I understand that concern. I also think, though, that we don't have the same concerns in bench trials with this issue that we do in jury trials. Would you agree with me?
I think that's right. Now, we still want good science regardless, but the practical matter is that the judge is going, even if you're making a motion on the expert witness, the judge is going to hear all the information anyways. And so he or she is going to have to sift through that. Whereas when you have a jury trial, the role of the judge as the gatekeeper is to not even let that information go forward if it's not being relied on.
Right. And I mean, to be clear, this bill went to the governor last year without that language in it. So I don't want to split hairs ad infinitum. But I will say that perhaps further elucidation that in bench tried cases where the parties stipulate that there's no need for Daubert motions, that at least that might be an exception. I would just hate to see people having to apply the Daubert standard when nobody really wants to and there's no jury. But I also don't want to take that concern past the point of reasonableness. We're talking about probably a handful of cases a year at that point.
I think that's right, Senator, and, you know, it's a valid point, I would say too, for practical purposes. If the parties don't want the standard to apply, they certainly don't have to make an objection, and that's always up to the party's discretion whether to be able to challenge an expert or not.
Fair enough. And I mean, I will say what I think you're going to see. I mean, you are going to see appellate decisions arising out of Daubert rulings in bench tried cases. It may not be the pinnacle of judicial economy. I'll just say it that way. Thank you.
Any other questions? Do you have witnesses to call, or should we just call them up?
You can call them up, Mr. Chair. Thank you.
Witnesses in support of House Bill 153.
I'll start off, Mr. Chairman, members of the committee. Ray McCarty, President of Associated Industries Missouri, and I don't think there's anything I can add to the expert testimony you just heard on the expert witness bill. If there are any questions, I also have a witness form to save time for Tony Nyhart before you go to something else and leave on record in support.
Thank you. Any questions for Ray? Thank you. Next witness in support.
Mr. Chairman, members of the committee, Brian Buck, Missouri Chamber of Commerce and Industry, like for record in support of the bill.
Any questions for Brian? Seeing none, thank you. Oh, I'm sorry, did you?
I was just going to ask, your energy level seems a little low this
It's
morning.
Next witness in support.
Good morning, Richard Brownlee. I'm here on behalf of State Farm Insurance Companies, Missouri Insurance Coalition, American Insurance Association, and Chubb Insurance Group. I think on this issue with these bench tried, and I think I can add briefly, in bench tried cases, the judge essentially can hear any evidence he wants. I mean, you can make all the standards, you can talk about the fine points. He hears the evidence and then he weighs the credibility of the witness, the training of the witness. All of those factors go into his decision. So you can make all sorts of extra rules about bench tried cases, but quite frankly, they're superfluous because, and I know you know that. I mean, it's just that we're kind of arguing about stuff that really doesn't go to the merit of I think, this bill. Yeah.
If I may, though,
Yes,
you are going to have appellate decisions based on Daubert standard in bench tried cases, where there is, I mean, where there need not be that. I mean, I just, as a client, I wouldn't be wild about paying for Daubert litigation in general anyway, but to have it in a bench tried case, which the bill in its current form allows, is, I would just say it's probably not a perfect thing. I'm also not saying that it's, I'm also not saying that it's going to be an issue in very many cases, just making that point.
well, to respond, I don't think you're going to have an appellate decision based on a bench tried case with Talbot where the court ruled that the expert was too well qualified either. I mean, it's going to be the other way, Senator. I mean, they're going to say this witness was so improper, so out of line, that if you relied any on his testimony, that would be improper. At least I think so.
And in fairness, you're not going to see 1,000 of these.
Correct.
Richard, while you're there, in his opening remarks, the representative made the reference to the U.S. Supreme Court law. Does the U.S. Supreme Court make law?
Sure.
Are they supposed to?
I don't know that. I think for a couple 100 years they probably have.
Inappropriate.
If you're a strict constructionist, the answer is no.
All right. Good answer. Thanks, Richard. Next witness in court.
Mr. Chairman, members of the committee, Orange on behalf of Washington University. Sorry to hear that list.
Any questions for this witness? Next witness.
Bill Gamble, representing the Missouri Railroad Association. We'd like to go on record in support of the bill and whatever you say.
Questions for Bill? Thank you. Next
Mr.
witness.
Chairman, members of the committee, for the record, Ryan Brown, representing the Missouri Petroleum Council. We'd also like to go on record in support of the bill.
Questions for Ryan? Thank you.
Thank you, Mr. Chairman. Nancy Gibbs, representing Eli Lilly and Company, also in support of the bill.
Questions for Nancy? Thank you.
Michael Gibbons, on behalf of Bill Ron Monsanto and Enterprise in support of the bill.
Questions for Mike? No, thank you.
Mr. Chairman, Kenny Jackson, Missouri State Medical Association, like to comment in support.
Any Questions? Thank you.
Chairman, Rob Jones, on behalf of the
Thank you.
Mr. Chairman, Jay Richard, Registered Blackness with the Missouri Hospital Association and Johnson & Johnson.
Questions? Okay. Thank you.
Mr. Chairman, members of the committee, Chuck Pierce on behalf of the Missouri Society of CPAs.
Questions for Chuck? Thank you.
Rich Albershon, registered lobbyist with Occupants.
Questions for Rich? Thank you.
Brian Bernstein here on behalf of the Missouri Organization of Defense Lawyers, one record and support.
Questions for Brian? Thank you.
Thank you, Mr. Chairman. Mark Richardson, Cole County Prosecuting Attorney on behalf of the Missouri Association of Prosecuting Attorneys here to support the bill.
Any questions for Mr. Richardson? Thank you.
Chairman Chris Moody on behalf of the Missouri Hospital Association.
Any questions for Chris? Thank you.
Mr. Chairman, David Overfelt on behalf of the Missouri Retailers Association, Missouri Grocers Association on behalf of the bill.
Questions for David? Thank you. Any other witnesses in support of House Bill 153? Seeing none, are there witnesses in opposition to House Bill 153? Welcome.
Thank you, Mr. Chairman. Members of the committee. I've been here before. In fact, I was here on the Senate version of this bill. Again, my name is Jay Benson. I practice law up in Kirksville, and I'm here in opposition to this bill on behalf of the Missouri Association of Trial Attorneys. It's been often said that this bill is a solution without a problem, and we believe that to be the case, and I'll explain different reasons for that. We believe this bill creates new problems. We believe that it is not a clear standard as stated, but that instead it creates more confusion than what we already have. And we certainly believe that it is not needed to give trial judges the power to exclude junk science. They already have that power in the process. I think Representative Corlew referred to it. It's a process called motion in limine, where the litigants can file a motion if they want to make a challenge in the form of a motion in limine. Current law was codified in section 490.065. I think the easiest way to explain it is current law is considered to be a credibility standard. It requires a judge to determine an expert's qualifications, and it allows the jury to determine who is more reliable. The judge determines whether the expert meets the minimum qualifications to testify on the subject matter and whether that testimony will assist the jury in deciding the case. Then, while a qualified expert testifies as to his or her opinion, the opposing party has an opportunity to cross-examine and contradict the expert's methods, opinions, and conclusions. The opposing party then puts on their experts, and the current law allows the jury to hear all the evidence and allows the jury to decide who and what is more reliable. This bill is a stricter admissibility standard. It requires a judge to determine the credibility of an expert's opinion before the jury ever gets to hear it. And we think that's bad. This bill focuses on the admissibility of the evidence itself, whereas current law focuses on the qualifications of the expert and allows the jury to decide how much weight that evidence should be given. We believe that this bill would allow a well-funded and prepared defendant to manipulate published research, and where current law requires an expert to prove his or her conclusions in open court. This bill, as we've heard, forces the trial judge to become a gatekeeper of the evidence. It allows the judge to make all the decisions about which witnesses are credible before the jury hears them. The jury should be making those determinations. Chief Justice William Rehnquist wrote in his dissent in the Daubert case, he said, a trial judge's duty is not to become an amateur scientist. And that's what this bill, we believe, would cause the trial judge to become. We believe that's what this bill judge does. We believe that the current standard is a better standard. Information is necessary to make good decisions, and imposing too strict of a test on what can and cannot be said to the jury limits information that is available to the jury. We believe that instead of excluding expert opinions, it's better to allow cross-examination in front of the jury and let the jury decide which experts to believe. But with cross-examination, if there are If one side believes there are deficiencies in the opinions or in the methodology of that expert, those deficiencies can be brought out in the cross-examination. Proponents of this bill have suggested that it will prevent the admissibility of junk science. I was at the House hearing on this bill, and Jackson County Circuit Judge Jack Great was there to testify in opposition to this bill. Now, I understand that the circuit judges are, I think that, as I understand right, they're still in opposition to this bill, but they're standing down because of some of the agreements that I understand Representative Corlew can add to this feels appropriate, but as I understand, because of some of the amendments that happened on the House floor, the judges are standing down in their opposition in their testimony, but I think that they're still opposed. But anyway, with respect to Judge Great's comments in the House hearing, he testified that he asked one of his clerks to conduct legal research on the issue in the appellate courts of when a jury was presented with junk science. And his testimony in the House hearing was that his clerk could not find a single case that concluded that there was junk science being reviewed or being considered. We also believe that this law presents an extreme burden and expense to the courts. There was suggestion that the bill doesn't require a hearing, and let's hope that there will be instances where that's the case. But in the federal standard, hearings are available, and sometimes hearings can be days or even weeks, and incredibly burdensome and incredibly expensive. And our trial judges don't have that time. I'm a country lawyer. I practice law in a country where there are country judges who many have multiple counties for a single circuit. And these judges do not have time to have long, protracted Daubert challenges with their dockets. It would be extremely difficult for them to do this. We believe that this rule is, as is proposed, is vague at best. We believe that it leads to costly, confusing hearings. We believe that the current rule is more straightforward, and we ask that you oppose this bill. When I was growing up, I always heard like the line, if it ain't broke, don't fix it. We don't believe that our system is broke. We don't believe that our current law is bad, and it is evidenced by Judge Great's testimony with regard to the research of the issue of junk science. That's all I have.
Thank you for your testimony. We typically do not entertain testimony on someone else's behalf unless you've been asked to testify on their behalf relative to the court. So.
And I'm here on behalf of the Missouri Association of Trial Attorneys. And candidly, I was mentioning that because I want to make sure I didn't overstate something because of what I understand of this circuit judge's position. But so I'm here on behalf of the Missouri Association.
Any questions for Mr. Benson? Seeing none, thank you for your testimony. Other witnesses in opposition to House Bill 153. I think everyone has been leaving witness form, so thank you for faithfully doing that.
Mr. Chairman, members of the committee. My name is Jason Hayden. I represent the railroad employees that belong to the Transportation Division of Sheet Metal, Air, Rail, and Transportation. It is our understanding, even with the amendments that were made on the House floor, the way it affects our members that fall under FBLA cases, 90% of their cases are going to go to jury trials, and this would directly impact their ability to openly and honestly explain their case to a jury and bring in the people that they work with daily that do the same job and have the same experiences that an injured employee might have. And we feel that it would limit their ability to bring those people in to speak to the jury and let them know the real story behind what should have or what did happen.
Any questions for this witness? Seeing none, thank you very much for your testimony. Other witnesses in opposition to House Bill 153.
Good morning, Mr. Chairman, members of the committee. I'm Ken Menges, registered lobbyist representing the Missouri AFL-CIO. We want to thank the representative for the changes made in the House for the non-jury trials, because that does affect workers' comp cases. But still, for our workers, the other workers that we represent that do have to go to trial, we think that the current system works best for our members.
Questions for this witness? Seeing none, thank you. Any other witnesses in opposition to House Bill 153? Are there any witnesses here for information purposes only?
Good morning, Rick Gowdy, Director of Division of Behavioral Health, Department of Mental Health. Very briefly, bring a very specific and very limited issue to your attention. I thank the representative for talking with us about it. We think the language in 490 creates a direct conflict with existing language in Chapter 552. You have a handout in your briefing book, I think. 552, a court can order the Department of Mental Health to provide an evaluation of a criminal defendant and offer an opinion as to whether or not at the time of alleged criminal conduct, the defendant knew or appreciated the nature, quality, or wrongfulness of his conduct. General counsel for the department believes that the language in 490 proposed is in direct conflict with that. We don't have any general concerns with the bill, and as the representative pointed out, we have proposed just a carve-out language to carve out those very specific sections of 552, specifically 552.020 and 552.030. So with that, I will answer questions.
Questions for this witness? All right, seeing none, thank you for your testimony, and we do have the handouts. Any other witnesses for information purposes? Seeing none, that will close the hearing. Oh, I'm sorry, Senator you back.
I'd like to wish Harry Gallagher a happy birthday.
All right, Harry.
You gave those up years ago, Harry. All right, thank you, Senator Modifies. All right, well, that will conclude the hearing on House Bill 153. Is there a motion to go into executive session? It's been moved and seconded that we go into executive session. All those in favor say aye. Opposed, no. Ayes appear to have it. The ayes do have it. We are in executive session. We advised everyone, I think, on the committee that we were planning to take this bill up, and so I would ask for a motion to take up House Bill 153. Thank you. It's been moved and seconded that we take up House Bill 153. All those in favor say aye. Aye. Opposed, no. I seem prepared to have it. The ayes do have it. So we have House Bill 153 before us. Is there a motion to do pass House Bill 153? It's been moved and seconded that we do pass House Bill 153. Discussion on House Bill 153. That's the bill that we just heard before us today. Justin, do you have any? I know you had some interactions, or do you have any comments or thoughts?
Yeah, I mean, we've covered this ground before. I'm not going to belabor it. I do think that DMH's remarks may very well result in an amendment that we're assuming we get that on. I don't think that's going to delay things by a great deal. It seems to me it's a process from whatever the Senate does, if it's anything other than
You'll be working on that, or with
yeah,
I think
it's pretty straightforward.
Okay. Any other comments before we vote? All right, Madam Secretary, would you please take the roll for the vote on House Bill 153 to do pass?
Senators Emery.
Aye.
Schatz. Eigel.
Aye.
Hunsinger. Rizzo. Bowden.
Aye.
Sifton.
No.
By your vote of 4 ayes and 1 no, we have do pass House Bill 153. I would entertain a motion to take up Senate Bill 183.
So moved.
Moved and seconded that we take up Senate Bill 183. All those in favor say aye.
Aye.
Opposed, no. The ayes appear to have it. The ayes do have it. We have Senate Bill 183. Of course, there is a Senate committee substitute for Senate Bill 183. Is there a second? Been moved and seconded that we adopt the substitute. Discussion on the substitute. Did everybody receive the substitute?
I don't know that I see
In
what does it
183.
do.
It changed and lowered the number of employees. Originally, the bill, the language was 50 employees, then he went up to 100. Sure. Discussion. I talked to him, I told him, maybe went the wrong way. So he lowered it down to 25 employees.
For the definition of small business.
That's right.
So we are going to be taking businesses out of the statute.
That's correct.
Well, it was 50 in its original implementation.
Right.
When it was in law.
Right.
This reduces the population that qualifies.
Yeah.
Got it. Yeah, I mean, I don't, yeah, I appreciate the explanation.
Any other discussion on the Senate committee substitute? I'm just reading the summary here just to make sure that we didn't overlook anything. I don't think that's everything. All right. We need to do pass motion on the second. Well, that's right. All those in favor of adopting the substitute, say aye. Aye. Opposed, no. Ayes appear to have it. The ayes do have it. We have adopted the substitute. Is there a due pass motion on Senate committee substitute for Senate Bill 183? Been moved and seconded that we do pass Senate committee substitute for Senate Bill 183. Any further discussion? Seeing none, Madam Secretary, please take the vote.
Emery,
Aye.
Schatz, Igel.
Aye.
Munsinger. Rizzo. Bowden. Sifton.
Aye.
By your vote of 5 ayes and 0 noes, we have due passed Senate committee substitute for Senate Bill 183. Seeing no other business to come before executive session, is there a motion to go out of executive session? Second? All in favor, aye. All opposed, no. Ayes have it. Is there a motion to adjourn?
Yes.
Moved and seconded, we adjourn. All in favor, say aye.